Thank you. You may be seated. We're here today in the case of Lane versus Lane. It's our case number CACV 180165. This is the time set for oral argument. Each side will have 20 minutes. Counsel for appellant is responsible for reserving any time that you may wish to have for rebuttal. These proceedings are being audio and video recorded, so we would ask that you identify yourself and your client the first time that you approach the podium. We've conferenced this matter this morning. We've read the briefs and are familiar with the record. And with that, we look forward to your argument. Counsel?
Thank you. Good morning. May it please the court, my name is Stephen Smith. I represent the appellant, who is seated to the back. Burl Lane, also seated in the gallery, is co-counsel Claire Lane. Your Honors, I wanted to bring a piece of information to the court's attention before beginning my argument, and that is, when we filed and submitted our case management statement, one of the questions addressed in the management statement is, are you aware of any other cases pending before the court that involve same or similar issues? At the time of filing it, I was not. As I was preparing for this oral argument and was reviewing some recent oral arguments on the court's YouTube channel, I came across a matter that was argued just last week. The case is Marriage of Driss, D-R-I-S-S. It is 1 CACV 18-0243. Also a divorce case, also involving a spousal maintenance claim, and a similar issue with regard to the appropriate attribution of income to assets assigned to a spouse as part of the divorce action. The court finds that it would be unreasonable for wife to access the retirement funds until age 70 and a half years. That sentence is why we're here today, Your Honors. That sentence appears twice in the ruling from the trial court. This matter involved a long-term marriage. Parties married more than 30 years. At the time of the divorce, both parties well into their 60s. They had raised 2 adult children. Husband had been a practicing lawyer throughout much of the marriage. Wife had been a stay-at-home mother throughout much of the marriage. The court held a trial regarding a spousal maintenance and attorney fee issue. Previous issues regarding property division and the like had been resolved through a mediation. A Rule 69 agreement under the Rules of Family Law Procedure had been issued. And the only issue before the court at the time of the trial was the support and attorney fees. The court found that wife would have assigned to her $78,000 for her share of a marital cabin, $200,000 approximately for her interest in the equity of the marital residence, a $17,000 account receivable, and more than $400,000 of retirement assets. The court found that wife was healthy and capable of full-time employment at minimum wage. At minimum wage. At trial, wife presented testimony from a CPA who was presented as an expert witness, who also happened to be her brother-in-law. The CPA, Mr. Hooper, testified that he counseled clients frequently regarding managing their assets in their retirement years. He testified that he typically recommended to his clients that they should avoid touching any of their retirement assets until they reach age 70 and a half. In fact, he testified, and I quote, speaking of wife, "In a perfect world, she would wait as long as possible. A perfect world would allow her to not have to take those funds until she is 70 and a half. Based on the reality of her situation, that may not be possible, but in a perfect world, that would be what I would recommend." Judge Sukenik appears to have seized on that testimony and made a conclusion that it would be unreasonable for wife to touch any of her retirement assets, principal or income or interest income, until she reaches age 70 and a half. The problem with this finding by the court is that it flies in the face of decades of precedent from this court. Precedents going all the way back to the early 1980s. In Dethridge versus Dethridge, the court was faced with a similar situation where wife was assigned property, real property, the trial court concluded that that real property produced no income and therefore assigned no value for purposes of calculating the spousal maintenance award. This court reversed and said even property that lays fallow, just real property sitting as a vacant lot, needs to have some level of income attributed to it. It needs to be put into some income-producing form because the trial court is required to look at all potential property income assets that a spouse may have to provide for their own reasonable needs before assessing what their need is from a spousal maintenance standpoint. In this situation, the trial court ignored that. It appears that what the court did was perhaps conflate some of the testimony from Mr. Hooper regarding age 70 and a half. The age 70 and a half is important because under federal law, individuals are required to start drawing from their retirement assets once they reach that point. You're allowed to have your 401k or your IRA sit, and you're not obligated to touch it in any fashion until you reach that age 70 and a half. And at that time, the law requires you start making minimum mandatory withdrawals based on formulas set by the Internal Revenue Service from that retirement account. The issue here is the court appears to have concluded that that was enough to justify that she not have to take anything. The law requires you must, but it doesn't talk about when you may start making withdrawals.
Could we conclude that the Superior Court was concerned that there was not enough money? Let's say it were a $20,000 fund, and the court just reached the conclusion that, well, $20,000 is not going to go very far. It makes sense to continue to accumulate income in that account until age 70, and that's going to be a relatively small amount that will be available to her.
It's a reasonable question, Your Honor, but understand that the position of the appellant is not that she should be required to touch any of the principal of that amount. The court was faced with a similar situation in Gutierrez, although Gutierrez is distinguishable on a number of different grounds. But the court was faced with a similar situation. In this particular circumstance, what we're looking for is that the court attribute the income from that amount, that principal amount. We're not asking for her to dig into it. And the Weiniger case would suggest that's reasonable. The Weiniger case suggests that a spouse should not have to eat up their nest egg in order to provide for their reasonable needs when facing a spousal maintenance claim. But something to note between all of these cases that we're talking about. In Weiniger and in Gutierrez, we're dealing with individuals who are not at retirement age. We're dealing with individuals, in the Gutierrez case, for example, Ms. Gutierrez was approximately 49 years old at the time of that divorce. She had roughly $100,000 left in her retirement account. The court made a conclusion that it wouldn't be reasonable for her to draw on that at that point. That's a reasonable conclusion. When you're still below the age of 59 and a half, which is another important IRS milestone. When you're below the age of 59 and a half, if you start drawing money from retirement accounts, you're going to pay not only the tax on that account, but a 10% penalty for early withdrawal. The government tells you, before 59 and a half, we don't want you to take it. We're going to penalize you if you do. They also tell you, 12 years later, when you hit 70 and a half, we're going to make you start taking it. Wife in this particular circumstance was in between there. She was in her 60s at the time of this action. She could take her money without facing any kind of penalty for early withdrawal. And by her own brother-in-law's testimony, the CPA, the only other witness who testified at the trial, she could expect to receive a 4 to 5% rate of return. In fact, his testimony was 5% rate of return is what is expected in the industry over the long-term life of an asset, over an investment, and that his recommendation to his clients is to use a 4% rule. He testified that that was based on a report from an expert back in the 90s who suggests that by taking 4%, you will be able to have whatever your amount in your retirement account is, whether it's $100,000 or $1 million or whatever. If you only take 4%, you can expect it will last your lifetime. In this case,
comforting. I don't know how realistic it is, but it's a good approximation, I suppose. But let's say that we agreed with that proposition, and the trial court took it into account. Would the result necessarily change? The
result certainly would change, Your Honor, because that $400,000 if we use that 4% rule, for example, and I'm rounding a little bit because it'll make my math easier.
Well, I said necessarily change. I mean, in other words, the court could say, I'm going to look at this 4%, 5%. I'm going to assume that it is available on a monthly basis, and that doesn't really affect my 319B analysis.
Had the court done that, Your Honor? Had the court said the court has considered all of the property assigned to wife in reaching its conclusion under 25319A that she qualifies and under 25319B in assigning the amount and duration, we likely wouldn't be here.
Okay.
Because the reality is if the court had said, I've considered it, the law is clear that the court is required, if it finds someone qualifies for maintenance under Section A, to look at the factors of Section B. It's not required to look at them all because some may not apply in a case-by-case basis. But in this situation, the court didn't do that. The court said, I'm ignoring that. I am completely disregarding that because I'm not finding it reasonable that she have to touch any of it until she's 70 and a half.
I suppose
which
then
in doing
I suppose then you'd have a compound error in your view, because not only is the income from the property not being considered, but actually the property is then undervalued, because if the income's allowed to accumulate, the nest egg would be worth a lot more by age 70 and a half.
It's part of the argument that we made in our brief and our reply, Your Honor, which is by doing what the court has done, the court has basically said that 4 or 5% per year can simply grow. So that $16,000 to $20,000 a year of income on that $400,000 will build up over the next decade and add another somewhere between $160,000 to $200,000 by the time she's age 70 and a half. And essentially what you're doing is forcing husband to pay spousal maintenance that in some respects is simply building an estate for wife to leave to whoever her heirs may be. And that is something that 25319 does not contemplate. Now, let's admit, the future is impossible to predict. No one knows for certain when wife may pass. No one knows for certain what sort of catastrophic events may arise in the future, what sort of health issues may cause her to have to potentially eat into some of that earlier than later. The reality is, though, and this will lead to the Podhoretz decision from Division 2, which we've cited in our briefs. The Podhoretz court found that in dealing with property assigned to a spouse, we're looking for property that will last that spouse's lifetime. And when we're looking at 25319A and we're asking the question, do they have property assigned to them that will provide for their needs? Podhoretz is telling us that property has to last their lifetime. It's hard to predict what that's going to be. But what that would tell us is at some point, there is an intersection where Deathridge and Podhoretz have to meet, where we're saying to a spouse, you have to be taking principal and interest to live upon, because the idea is that property at some point is going to be depleted at the end of your life, to where essentially you're spending your last nickel, hypothetically, as your head is hitting the pillow in the casket. We're not asking for any of that for this purpose. All we're saying is this court made an analysis that wife qualified for spousal maintenance under 25319A, and one of the things the court's required to look at in making that conclusion is, does the spouse have property assigned to her that can provide for her reasonable needs? This court ignored that, and therefore by ignoring it, that decision about the qualification has to be looked at again. I don't think it's up to this court to say that wife does or doesn't.
One of the factors, and you're eligible for, wouldn't that factor be more properly considered under B, going to the amount
It falls under
of maintenance?
both. Property assigned to the spouse falls in both parts of the statute, Your Honor. And it is in B9, you're correct. The property assigned to that spouse gets to the calculation of the amount and duration under Section B9. But you also look at it when you're asking the question about qualification. The statute under 25319A specifically states, lacks sufficient property, including property apportioned to the spouse, to provide for their reasonable needs. Now,
Is that one factor?
It is.
among
And
others?
Appelli brings up an interesting question, which is you could find under other sections 2, 3, or 4 of the statute. And by the way, at the time, the statute had 4 subparts in Section A. It's now gone to 5 subparts under a change the legislature had made. But you could have found under Part 4 that she had a marriage of long duration and is of an age that may preclude the possibility of gaining employment to be adequate to be self-sufficient. But the court ignored that other income. So if we're asking the question, can you get income to be self-sufficient? We'll concede long marriage. When we're asking the question, are you prohibited from getting income that could be self-sufficient, the question has to be, what are your needs? What passive income do you have that can help meet those needs? And again, we're not asking to touch the nest egg, only the income. And then if there's a shortfall, what employment can you get? And because the court ignored that passive income, we suggest that they erred. One other point. It is possible that a court may find that an individual may qualify for an award of maintenance, marriage of long duration, and yet in looking at the overall totality of the circumstances, given all the different factors under 25319B, that the court may conclude that the amount should still be zero. We may be talking about a distinction without a difference, but that possibility exists. What we're really focused on here, though, Judge, is this court made a conclusion and entered an order for $2,500 a month of maintenance, and in doing so, tells us twice in its decree, I'm ignoring that potential income from the retirement assets, and in making that choice, we believe the court fundamentally erred. And I would like to reserve the final 5 minutes of my time.
Good morning, judges. My name is John Herrick, and I represent the appellee, and Kathy is sitting right behind me in the audience section. I am pleased that counsel has indicated that the only issue is the whether or not to invest or take the interest income from the IRA at this time. In their brief, and as counsel closed his argument, basically arguing that subsection A is still debatable. I think that's a foregone conclusion that Kathy qualified under subsection A. What counsel was arguing is that you take A and D and add them together to see if she qualifies. And that isn't what the statute says. He wants to take her investment income and add it to her minimum wage income and say that is now sufficient. And that's not what the statute and the case law says, that you look at, and if you qualify under any one of those, then you qualify for going into subsection B. Now, the other thing that counsel said that I have to disagree with is that he said that the trial court ignored the investment return on the IRA. And that's just not so. I agree that the trial court is required to consider all property, as Deathridge says, but as Gutierrez says, that you're not supposed to have to spend down your retirement. There's another opinion, Kelsey, which was not cited, which basically stands for the same thing, that the trial court should give consideration to that income. And fortunately, in this case, the trial court did. And I want to refer you to 3 parts in the decree, which is on page 6, lines 21, 25. The court says that it would be unreasonable for wife to have to access that at this time. And then on page 9, lines 10 to 14,
You're saying that evidence is that he's considering the amount of interest that it's earning?
I'm saying that means that the trial judge considered the interest income and said it was not relevant to the final ruling.
Did the trial judge say specifically that it was considering the interest income? Or should that be read more fairly to say that it's unfair or inappropriate to make your client invade the principal before a certain age?
Well, and I don't think the trial court used the word interest income at that particular juncture.
Did the trial court even consider income on this corpus, or was the trial court more focused on this idea that your client shouldn't have to spend down the principal before a certain age?
Well, I'm not sure what all was in the mind of the trial judge, but
Well, but let's look at what the trial judge actually said.
right. But what he said was that it's $2,500 a month for 5 years, it followed by a drop to $1,000 a month for 4 years, and then to zero. And the argument that I would make is that gives justification for allowing Kathy to maintain her investments, to let them grow a little bit, so that when that step down occurs and then eventually to zero, she will have an investment that can make up for that shortfall.
Well, let me take you through it this way. I think it's fairly clear from the arguments we've heard today that there's not an argument that the trial court should have made your client spend down principal before age 70 and a half. So let's take that off the table. The only argument I'm hearing is that in determining duration and amount, the court should have taken into account the income stream, hypothetical or real, from that corpus. Is that fair so far?
I agree.
Okay. Would you also agree that the trial court should have at least considered the income stream from that corpus?
And I respond by saying the trial court did.
Well, no, but I'm asking it in a different way. You would agree that the trial court should have?
The trial court should consider the alternative investment income that is available.
Okay. And is there anything other than sort of a reverse engineering of the duration and amount from which we might infer that the court considered the income that we can rely on to say that the court did?
Well, I've cited to you 2 sections of the decree that covers that, I believe, and there's 3 altogether.
But they're sort of, those sections of the decree don't explain a rationale, they just sort of set forth a result.
Well, in the decree, page 10, lines 14 to 20, the trial court does say that so that she can maintain that retirement account without dissipating her retirement assets.
Which sounds to me a lot like without spending down the principal. That's what dissipation means to me. Do you have a different interpretation?
Not for the word for dissipation, no.
Okay. So, I mean, if it sounds like the court was saying, I want to make sure that the principal here is preserved until age 70 and a half, I don't want that to be dissipated until that age, I think everyone in the room agrees that that's reasonable. What I think there may be some disagreement on is whether that amounts to a consideration of income.
Well, I can...
And if you have something to point to, please do.
I can only point you to the language that I have already cited to you, which is that the trial court said that she should not have to dissipate, that she should not have to access her retirement funds until age 70 and a half.
At what level did the trial judge value the retirement funds?
He valued them...
What was the number?
Well, the wife's half was around $420,000.
Okay, and did he consider that $420,000 would, according to all the testimony in the case, increase rather substantially by age 70 and a half?
That testimony was not in the record, that it would increase.
Well, there was testimony that it should earn interest at roughly 5%.
Well, I would say at 4%.
Okay, 4%. I mean, some of us may consider that even to be optimistic, but that was the testimony.
Yeah.
And
if you look at year to date this year, that's way optimistic.
Precisely. So, and we don't know, unfortunately, you can look at a 100-year history of the economy and say 5% is average, but we're talking about a fairly short number of years here, so we don't know what the return's going to be. But the court was entitled, I'm sure you would agree, to assume some rate of return. Right. Okay. In valuing the corpus of the retirement fund, did the court take the present value and estimate some increase by age 70 and a half, as far as you know?
As far as I know, the answer is no. And also, in response to your comment, the division of the retirement account was obtained by the parties by a Rule 69 agreement, settlement agreement that was reached before a trial. So there was no, if you will, valuation. It was simply taking account values as of date of distribution.
Okay.
But I do want to share with you that Judge Swan, I really disagree with the concept that what the trial judge said does not show that he considered the financial accounts and the interest and the investment. I think that the wording of the decree says as much. So the end of that particular issue, I think, really is that, as has already been cited, the Gutierrez case says that the wife should be able to continue to hold her retirement account without withdrawing from it. There was never any discussion in the Gutierrez opinion about the fact that, well, she hasn't reached 59 and a half, so she can withdraw it.
But this is beyond that. This is, you wait till age 70, which is presumably beyond a normal retirement age. It seems like there are a lot of unknown factors going forward. Husband may choose not to work going forward. There would be changed circumstances. It seems odd to arbitrarily note that age 70 is going to be the date of that she has to tap into retirement funds.
But then that was sort of coincides with the reduction and the step down in the spousal maintenance. She was 61 at trial. 9 years of maintenance takes her to 70. So I think that is the logic, if you will, of the trial court. While the trial court didn't outline that in so many words, that's the effect of it. So,
Counsel, let me ask, you've heard appellant's counsel mention this kind of sweet spot between 59 and a half and 70 and a half, where monies can be withdrawn without penalty but not mandatorily from retirement accounts. Do you view that law differently, or do you agree with that?
I agree with that.
Okay.
And there's nothing about this particular retirement account that would impose a restriction until husband stops working or something like that. It can be accessed anytime after age 59.
After 59 and a half. Basically, the retirement account that Kathy has is now an IRA. So the basic rules would apply to her. There's nothing special.
And if the corpus were shares of stock that actually paid meaningful dividends, would you take the position that those dividends should be reinvested, or that they should be considered as available when paid?
They should be reinvested, because the growth at age 9 years later, after the alimony runs out, Kathy is going to need more than what was in there at the time of the divorce. Otherwise, she loses, from the standpoint that with inflation, with Social Security coming into play at age 66 and 2 months for her, at least for normal Social Security payment, and she's going to get eaten up with inflation and her expenses. Her expenses, the budget, was right around $60,000 a year. Now we can knock off about $3,000, I think it is, for the car payment that had to be paid at the time of the divorce. But, the trial judge didn't find that her needs were $2,500 a month. The trial judge, the only testimony as to Kathy's needs was her affidavit of financial information and her testimony. And then the husband testified and complained about a $250 a month expense for Kathy to go see her family in California. And that's it.
There's nothing inherently unreasonable about the argument you're making, but we're left to speculate a great deal about what the trial judge actually examined or did. All we know is the result. And there are certainly ways to justify that result. You're doing so now, but we really have no way, as far as I can tell, of knowing whether the trial court faithfully applied the requirements of 319B in reaching that result.
Well, Your Honor, I guess you and I read it differently, because I thought that the trial court did state what its opinion was in the 3 references to the decree.
And counsel, let me ask you, though, if there's any doubt in our mind collectively, if we were to remand for the trial court to look at that again, he would know, right? I mean, he could tell us, because it seems to me that one or the other of you at the end of the day is right. But if we can't tell, that leaves an unsatisfactory sort of result on appeal unless we have more insight.
Well, Your Honor, that's a very optimistic view, because if there is a remand, we don't know for sure that we're going to still have the same trial judge.
And I understand that, and that's the risk of rotations and many other things. But I am an optimist. And anyway, please continue.
Well, I would say your optimism should be probably focused more on 25-327, which allows the husband to come back in when there's been a change in circumstances and seek modification.
And I understand that, and that is an available alternative. What we're asked to do is whether, the sort of operative agreement was done correctly in the first instance, and that's what we're wrestling with.
Well,
Do you acknowledge that specific findings of fact and conclusions of law are required under 319B, or do you think that those findings are relaxed in this setting?
Well, first of all, nobody requested findings. And second, I believe the case law suggests that there should be findings so that an appellate court on review can understand what was going on. I don't know that it's
Which
required.
I guess is the essence of the discussion we're having today.
Correct.
Okay.
But the other part of that is that unless the appellant can show that there has been some type of error, then it's to be affirmed. And the spousal maintenance award is the appellate court is supposed to defer to the, if you will, wisdom of the trial court on that particular issue. And hopefully that's what the court will do. Any other questions? Then I'll take my seat. Thank you, Judge.
Before you get going, I do have 2 questions for you.
I'm sorry?
I said before you get going, I do have 2 questions for you.
Absolutely.
First of all, is 319A at issue in this appeal anymore?
I believe 319A is at issue in that by ignoring the income-producing potential of the corpus of that retirement asset, the court invariably reached a conclusion for qualification. The court was specific about qualifications.
Are you contending that there should not be eligibility for maintenance under 319A?
I'm contending that that's a question that needs to be looked at, yes. I'm contending that the court needs to consider that income potential. If we look
you're asking us to reverse the 319A determination and hold that there is no maintenance the eligibility because there's the prospect of a minimum wage job?
No. Let me be clear. I'm asking you, yes, to reverse the finding that she qualifies and simply remand it back for the court for a retrial. That's what I'm looking for, because we're asking for the court to look at 25319A under the context of she's going to have minimum wage potential and income potential from this asset, and therefore is there a gap in those reasonable needs?
The result you're seeking is a remand, and then when you go back to the trial court, you would argue that there's no eligibility for maintenance at all. Am I correct? I just want to know what's at issue so that we don't leave our decision half done.
So, Judge Thuma asked a question that caused me to start to consider whether the court is considering the possibility of simply remanding it back for further findings. I don't think this is a matter that should go back for further findings. I think this is a matter that should go back for a retrial de novo, because I do believe that it's not for this court to make a decision about whether she qualifies or not.
Okay, so I really thought this was a yes or no question. I'm sorry it's taking so much of your time, but I just want to know if we did not address 319A in our decision from today's hearing, would our job be done? Or do you feel that this decision needs to address eligibility under 319A?
I think it needs to address eligibility under 319A, and the reason I feel that way...
I don't want to take more of your time with that then. Fair enough. The other question I had is, there's been a lot of discussion about, and I think some general agreement about what the trial court should consider in reaching a discretionary determination under 319B. We know the result. We know there are arguments for how, even with the consideration of every proper factor, the court could have gotten where it got, or how it might have arrived at a different conclusion. Generally, our law in this court requires us to affirm if we can affirm on any ground. In the absence of a request for findings of fact and conclusions of law, why wouldn't we simply say that this discretionary decision could have been justified had all the correct factors been considered, and affirm?
I don't disagree with your assertion of the law, Your Honor. And let's be clear, this court's required to take all the findings in a light most favorable to the appellee. I agree with all those things. But there's been a great deal of parsing about what the court, quote unquote, considered. It feels as though there's been some argument about what the meaning of is, so to speak. Let's look at exactly what the court's language was. The court's language was very specific, that wife should not be required, that it would be unreasonable for wife to use her retirement funds. That was the word. Not principal, not interest, funds, globally. The court basically made a finding that she shouldn't have to touch any of that. Okay. And in making that finding, by ignoring that, the court ignores the mandate of Deathridge, the mandate of Weiniger.
But why can't we assume that the court considered the fact that it would be earning income up till age 70, and that would be the amount that would be necessary to satisfy, to meet her needs at that point? And absent some request for more specific findings, couldn't we assume that the court actually considered that this retirement account was going to continue to grow for several years, and that amount would be the amount necessary to meet her needs?
I think that's, yes, you're allowed to conclude that the court, made some findings that would have supported its decision, but the findings that it did make, I think, contradict the idea that maybe they made that finding.
But if the court said, I don't want wife to invade her retirement funds until a certain time, could that not be interpreted to mean those funds as they would exist with growth and reinvestment?
That is an incredibly broad reading, I think, of what the court actually said in this particular circumstance. If the court had considered the idea of, I want this to be able to grow, the court could have said, I'm expecting a 5% rate of return over the next decade between age 61 and 71, and therefore
the court heard testimony on just that point, and we have to presume that the court took into account the evidence that it admitted. So if the evidence was there's a set amount in the beginning and it's going to grow at a certain rate, and the court says, I don't want her to invade those funds before a certain date, under our fairly broad doctrine that we affirm if the decision is affirmable on any ground, and absent a request for findings, we assume that the court made the correct findings, how do we get to a reversal here?
Well, again, I think the point was made. The case law does tend to suggest that under an analysis of 25319, the court is expected to analyze the factors and make findings regarding those factors. In the absence of, whether there's a request for findings of fact or not, the court is not simply allowed to issue a decree that says, I heard all the testimony, $1,000 a month for 5 years. The court has to do that analysis and present this reviewing court some amount of findings to look at and conclude that the analysis was properly done. And so in that regard, starting to add extra findings that weren't actually, and I say I'm out of time, I'm sorry, but add extra findings that weren't actually in the record, particularly in the face of the one finding that was made that again, flies in the face of almost 40 years of precedent, I think is a bridge too far.
Thank you
you.
both for your argument. We'll take this matter under advisement and issue a decision in due course. With that, we will take a brief recess.